Good evening, friends. Welcome on this special webinar on the company Fresh Start scheme. There is many more opportunities in this scheme for all the professionals who are in the practice. We are having multiple personality with us, starting with CS Praveen Soni sir, Central Council Member, ICI Institute of Company Secretary of India. We are welcoming you, sir. We have CS Gunjan Vijendra Jain, Company Secretary, Secretary of Vasai branch of ICSI. We have a CA Vijendra Jain, Secretary of Vasai branch of WRC of ICAI. We have a Vice Chairman, C. Abhishek Kumar Tiwari ji, Vasai branch WRC of ICAI. We have our faculty, CS Vinit Nagar sir from Ahmedabad. We welcome you all. Without wasting much time, would like to introduce our today's keynote speaker, CS Praveen Soni sir. Mr. Praveen Soni is an MCom LLB FCS and a Central Council member of the Institute of Company Secretary of India. Sir is the only Central Council member from employment sector and is presently Chairman of Financial Service Committee and Placement Committee of the Institute. He is also member of TEFC Committee, Examination Committee, PCS Committee, Research and Publication Committee, Secretarial Standard Board, and the Regulation and Chapter Guidelines Committee. Sir is only Regional Council member of WRC of ICI during 15 to 18 and has served as a Secretary and Treasurer for the year 17 and 18 respectively. Sir has started his career with corporate since 2005 as a CS in employment and has been in the industry ever since. During his past more than 15 years, he has served Data Infosys Limited, Jaipur, Viraj Profile Limited, Boisar, Tarapur, and Trimax IT Infrastructure and Services Limited, Mumbai. Since past 11 years, he is serving CMS Group and presently working as Company Secretary and Compliance Head for CMS Infosystem Limited, Mumbai, the largest cash logistic company in India. During the year 2007, Sir was elected as Secretary of the Jaipur chapter of NIRC of ICI. He was instrumental in the formation of Bhayandar chapter at Mumbai in 2012, and during the year 2012 to 14, he was Secretary and Vice Chairman of Bhayandar chapter of WRC of ICSI. During 2018, Sir has played key role in establishment of 4 knowledge centers, that is at Ghatkopar, Mulund, and Vasai Road at Mumbai, and Vapi at Gujarat. During 2019, he worked hard to make the dream come true of establishment of corporate study circle in Mumbai, that is Reliance Capital, Mulund West, Reliance Industry, HDFC, L&T, Mahindra & Mahindra, Aditya Birla. So with this introduction, now would like to request CS Praveen Soni sir to have to deliver a keynote address for today's our special webinar on the company's Fresh Start scheme. Over to you, sir.
Thank you so much. Thank you so much, Viragji, for inviting and your graceful invitation. And it's my pleasure to being there. And I came to know because you are doing this good task through your organization called Connect Easy. And I came to know that you are connected with the members in so many of years, I think decade of years. And it's surprising that you are dealing with the more than 10,000 number of members. That is a very tremendous task, especially when I came to know that you are handling more than 100 numbers of WhatsApp groups. So it's a tough situation for us to handle if we have already 10 groups as an administration, but 100 plus groups is really in commendable things. And to manage the same, I don't know how you are able to get the time and to manage the mechanism for the same. So that's a very tremendous task. I appreciate you as a good thing and a very wonderful kind of services you are giving to this profession. So thank you so much.
Because of a passion for the profession, so it's possible to manage everything.
Good. Because I know I've seen you 2 years before also. So that's
yes.
Good. I really appreciate the same. Thank you, your colleague to your Vasai chapter, Abhishek Tiwari, my dear friend and committee member into, I think, Secretary of Vasai branch of ICI, and my own friend and member, Gunjan Jain, she is Secretary of Bhayandar chapter of ICSI. So it's a very good connect and with all the people. my own member from the institute for the day, Vinit Nagar. I think we are going to have a good session, and he has prepared a presentation also. So we are going to have a good session on this. So I'll be try to speak rather than on topic, because topic we do have a good speaker. So I'll try to speak on the non-technical part, and somewhere on the institute how we are going forward and we are doing. Friends, I believe if I talk, I come to know that into this workshop more are numbers of chartered accountants, and some are from the company secretaries, and some are from CMA also, some are bar professionals also. More than 150 people we are there, I'd been told. So friends, I think it's a good time for all the professionals. First of all, it's a challenging time because looking at this COVID situation, people are very much afraid and how to do work, and they are not able to work completely. But I think it is a very challenging situation, and we Indian people are able to get the opportunity in all challenges. So we are very much efficient and capable to find out the opportunities into the challenges. If I ask about, I think CA Institute are also doing well. They are also doing lots of things into webinars, and on e-mode basis, the president itself is very vibrant. If I talk about company secretaries, yes, I'm witness to most of the things, and we are doing lots of webinars. I think this would have not been possible if the COVID situation was not there, and we would have been working on an offline and physical meeting basis only. But now we took the encouraged the opportunity from this COVID situation, and we started working on e-mode basis. Now the speaker from Kerala, people are from Jammu and Kashmir are hearing him without any additional cost, and he can also deliver the session without so much of hectics and traveling schedules and pains and all that. So it's an 3 hours of contribution, means 3 hours only. Otherwise, earlier it was counted as a 2 days workshop, because a person has to travel at night before, then have to stay at hotel, and then next day to deliver the session, then to get back to his station again in the evening, and late night is reaching. So that kind of traveling we were having generally when for any single meeting we are supposed to have. But now because of this COVID, the 3 hours means 3 hours only. Let's say 1 or 2 hours before IT preparation is required. Otherwise, for a technically sound person, we can manage the same thing in 3-4 hours only. So that's the, I think, opportunity we engaged from the COVID situation. Now, if I talk about the crisis, yes, we can understand the same from the man of developing India, Mr. Modi. That is how he has managed the crisis. Earlier, we came out, no, first we will save our people. So that was the intention. Then slowly, after passing of time, we come out with the Jahan Hai To Jahan Hai, and we created the PM Care Fund. Then after come out with the recent step of Atmanirbhar Bharat, and then local to vocal. So that is the very important thing wherein we can understand where India is going on and what kind of contribution the government is looking for from the professionals. Recently, our president ICSI has also given the award for professionals as a company secretary to coronavirus, like we are awarding to the corona warriors to policemen and doctors also. Our people are also working day and night in spite of the COVID situation. They are ensuring that the returns of the various companies, listed companies, unlisted companies, are going to file with the SEBI and ROC and MC on timely basis. We are doing secretarial audit also. Lots of things we are doing. Our precious committee led by our member chairman, Mr. Deepak Khetan, they had come out with the various modes and initiative by which on E mode the secretarial audit can be conducted. Various initiatives have been how to reach the data of the client by data room, by access to the laptop, or to by having scanned copy, then having digital signature on the minutes, and then filing of documents with a digital signature on it, so that on your letterhead and seal and marks, etc., is not required. So that is one of the biggest initiative I think the institute has taken. But now it's time for I can say I had seen some of the promoters where the companies were family promoters, family-owned promoters were there. They have started discussing on the dining table about the company's profession, companies going forward, to take the contribution of the family members, those who are the family members and they are on the board members. Let them educate, let us take their views also, because we cannot move out. So let us start taking discussions on it. And then we are growing the family owned board to the professional governance by giving more time to all the family members, and to educate them and to take their inputs also for the growth and development of the company. So I think it is the time when the people have started discussing, And then again, Institute has also started working on various relaxations to be given looking at the COVID situation. 2 times, I think ICSI has already postponed the examinations on the best possible dates which are available, so that we don't want to take risk of any single person. It is very clear mandate from the president. We don't want to take risk. At the same time, we don't want to be deprived of any person who is actually, because we are getting lots of messages that yes sir, we have already prepared for the examination and we want to appear, please allow us to appear for the examination. So institute is taking the holistic views, and in the interest of maximum number of students, the decisions are being taken. So that's why the 2 times the examinations has been postponed. Again, lots of relaxations has been given to the old syllabus students, those who are having the last group as last chance to appear for the examinations from the finals. And again, recently the relaxation has been given to change your exam centers. Let's say someone has earlier filled the examination center of far distance away, but now because of COVID, he is unable to travel, or if he is having some relative or friend at some other station, so he can change the examination center also, change the medium also. I think change the and one-time relaxation also been given, whereby the student can opt for, in place of June, he can attempt for the December examination also, and by that he is able to postpone his examination, and that too without any further cost, and the fees paid for the June examination will be transferred to the December examination. This is some of the important innovations, I think I can say, which has been come out from the COVID situations only. Now, if I talk about how to work we have on the same, I think if you want to see the best example of work from home, we can see the example of Reliance Jio and the Facebook acquisition which has been done. So wonderful task has been done. It cannot be said that it is completely during the lockdown period, but yes, one of the good results we have seen. Then the right issue also, biggest right issue from the Reliance, and that's one of the good things we can say. Yes, everything can be possible from working from home, and now even corporates are saying that yes, work from home can be a permanent solution also. Why to invest so much of amount into taking lease premises or purchasing the buildings and infrastructures and making makeovers and all that other premises? Let the people allow to work from home also, because we are getting good result also and flexible working hours also. That way families are also happy. So that can be one of the big and one-time solution. And some companies like Google have already worked out on how permanently the people can work from home. So that is one of the good thing. As regards the advices and suggestions to the government, yes, Secretaries board which has been constituted by the ICSI, including the Financial Services Committee of whose I am chairing. I think each and every recommendation which has been issued by the MCA or the SEBI, the institute has put a day and night meeting on a web based only, and taken views of most of the members and submitted to the same, including various elections which are expected by the members. So that is one of the biggest thing which we did have achieved through the lockdown period only. If I talk about the placement, I think as a member of the chairman of the placement committee of the ICSI, I have certain assumptions, certain recommendations, and certain understanding to the best of my abilities, and which I have seen from the data and availability of the information from the institute to me. Friends, first of all, since I am an experience, I am expertise having employment as a company secretary in corporates only, and I would say this is really a tough time for us. Yes, I agree and accept. Yeah, this is tough time, and I have heard that lots of people have got the salary cut, or some of them have layoff also. We are working on them to help them to the best of the institute's abilities. But yes, I think we need to understand this cannot run so longer. This is very small period, but yes, tough time. We need to have a better use of it, a perfect use of it. Now, how to do better use of? First of all, in this time, please don't think of jumping from the organization, and don't change the companies and organization, because this is time of instability. So please don't jump, and kindly keep serving to your existing organizations only. This is my first advice to you. Secondly, I think this is the time to use this. This is the best opportunity to use this time, this COVID time, wherein we can upgrade our skills, we can update our skills, we can utilize time to gain the knowledges and to intensify the level of knowledges of the profession. So I think I have heard that some of the company secretaries have started working on the reading of the Companies Act from beginning itself, because otherwise you have not been able to get the time for the same. Some chartered accountant started reading the income tax again, because it's a very good thing to learn and understand the things. And sometimes there are certain sections where the amendments are there, but which we are not practicing, so we are not reading it. So now it's the time to thoroughly read the income tax act once again. there are people, those who are already appearing in the insolvency examinations, and then RVO, I think Institute ICSI has already done more than 5 sessions of RVO on online basis, which was otherwise not possible. I'm sure, because earlier it was very tough when the physical examinations, physical classes were there, because people has to move physically. So it was tough to hold, to get the more than 20-25 people. I think it was not easy. But through the online method, people are registering through 60-70. It is always full, and there is a huge queue of people, those who are willing to register for the RVO. So it's an hunger of the knowledge, and to intensify your upgrade and to upgrade your knowledge base. That is very much into the professional. That is always acceptable and welcomeable. So people have joined in a bigger number into gaining knowledges. At the same time, if I talk about the ICSI, various crash courses has been started, which are employment oriented, which are improving your personal capacity in terms of professionalism. Some are on the women director, then independent directorship, then CSR, then arbitration, and then NCLT. These are huge kind of certificates courses which has been started by the institute, which are actually upgrading and adding some values to yourself as a professional. If we see that NCLT has now also started working on online basis, online appearances are there, and that's a good thing that we are even governance and regulators are also using the best use of its time. But friend, let me tell you, this bad time will not run for always. I think after 1 year, we are going to see a golden era of the country, wherein I believe various countries, even from I think South Korea or Japan or the US already, and then India also, they are switching their operations from the China. And I think Mr. Modi, who is already welcoming them with the red carpet, we are going to see a huge amount of industries from various nations and huge amount of investments. And then I can foresee a huge amount of placement and employment opportunity will be there for the professional, for different skilled of employees. So that is the best area, best time we are going to see. It is the time to improve your quality and ability. It is a time to improve your presentation and communication skills, which is definitely going to give you good value after, I think, more or less hardly a 1 year period of time. So that's the best thing I think I can say. As regards the initiatives, yes, from ICSI, I can say placement portal we have recently initiated, wherein last year we inaugurated in the National Convention Center Jaipur in the presidentship of my colleague Ranjit Pandey, and it was the first full-fledged placement portal which is working on a matching concept, wherein any additional qualities you do have apart from company secretaries, that will be matched there. Like you have expertise of working with the litigations or police authorities or ED or RD or RBI or listing obligations or anything banking, etc. That all will be placed there. And any company looking at company secretary with 10 years of experience, having expertise into ED or RD something, it can be cashed easily. So that is the best thing. Again, we are working on international tab also on the placement portal, whereby the international opportunities to the company secretary which were scattered earlier, now it will be at a centralized place and people will be able to see it very easily. At the same time, those who are company secretaries staying outside India, they will be able to see their opportunities available to their countries from the same portal. I'm also working on the software system into the placement portal itself, wherein people will be putting their informations and the system will generate automatically full-fledged and a wonderful kind of resume so that they can use it and they can share it. Friends, I think this is the best time when people can use it. We have already, as a placement, we have already worked upon institute to work upon with the UGC also, and because in UGC, under UGC there are 45,000 of around colleges into India and more than 1,000 universities, where for any professor they require the degree of law or MBA, and I think some other degree they are asking. We have requested them to add the company secretary degree also to that, so that that will open at least more than 50,000 jobs on a yearly basis for the professionals. So if our people are eligible for that, technically they are, yes, they are teaching also. We have some good company secretaries on penny day basis who are into this, but formally they can be as a professor, and it will open a huge amount of new pendant of new gateways for opportunities for the company secretaries. At the same time, we are also working with the various universities also, wherein we can have good opportunity and tie up for the professionals also. So I think, friend, this is something typical area, typical time we are working. As a employment, I have already communicated. Yes, we need to time. It's a time to increase your job profile. Please start serving to the company in any mode where you can, whether it is finance, it is treasury, it is legal, HR, IR. These all things are very much concerned to us and very much relevant to us. Litigation, non-litigation, wherever you can perform, I think you should appreciate, you should contribute to the company. At the same time, those who are practicing professional, it's time to change and to diversify yourself rather than sticking on the company secretary or the compliance portion only. As rightly told in the PCS Day program on 15 June, when the Anurag Singh Thakur, the Honorable State Minister of Corporate Affairs, was there, he has communicated, and Mr. Pandey was also there, who was Secretary, Joint Secretary of MCA. It's time to convert yourself from company secretary to corporate secretary. So, wherein you can contribute to more other corporate and legislations, including income tax, I would say. So, it's a time for all the professions. I would not say for the company secretary, this applies to everyone. So, even chartered accountants also, just to gather the knowledge and diversify your areas of business and start working with differential streams also, and allied stream also, with having some good alignments. So, I think it's a time for us to diversify your businesses and practices, so that you can contribute in the best manner to the organization, in the best manner to the industry and your client base and to the nation. So that is the time I think we are seeing. And friends, no need to be get demotivated, like we are seeing some of the newses into the from the medias and from some people from industry, film industry also. But this is not a way to surrender yourself. Your life is nothing. I can say the a copy of your mark sheet or some of or any single failure has no value in terms of the life. It is very big, it is very challenging, and it depends on you how you take it and how you take the responsibility of the people, your family members behind you. So it is the time for us to brush yourself, to brush yourself and to gain more and more knowledge and more and upgrade yourself, so that after a period of time you will be coming out as an thorough and sound professional, and who can serve to the industry and the company in a multifactorial way, in a wonderful manner. So with this, I would like to sum up and close my address to this organization, and my thanks once again to the organization, all the organizers, including Virag Shaji, for inviting me. And I would say that this is good initiative you have taken through the Connect Easy, and keep continue with the same. This is wonderful thing, and it is something which you are doing without having any designations or assumptions, and any hope for this, any intention for the same, I would say. I know there are some costs behind this, because into the institute I can see. So I don't know how you are matching it, but whatever you're doing, it's a best thing. Thank you so much once again. All the best. Thank you.
Thank you so much, sir, for your motivating speech and also informing about the institute activities and all the guidelines of the institute and other things regarding MCA and ROC. Now, without wasting much time, would like to request Abhishek Kumar Tiwari, Vice Chairman of Vasai branch of WRC of ICAI, to introduce our today's faculty, CS Vinit Nagar ji. So over to you, Abhishek ji.
Thank you, sir. Today we have gems of CS, Mr. Vinit Nagar, very dynamic and young CS. Mr. Vinit Nagar is practicing company secretary and is having overall post-qualification 10 years experience. He is founder of Messrs. Vinit Nagar and company secretary. His core area of practicing, including appearance before the NCLT, NCLAT, ROC, Regional Director, Ministry of Finance, SEBI, and Secretaries Appellate Tribunal. He majority deals in the matter of corporate law advisor and handles the matters relating to the shareholder management dispute, removal of auditors, compromise arrangement between the company and creditor, merger acquisition, amalgamation, handling inquiries, inspection, investigation matters under the Companies Act, and many more activities relating to the ROC and pertaining to insolvency, resolution, or process liquidation, corporate debtors. Since last one of decade, he is dedicatedly engaged with the Institute of Company Secretary of India in spreading the awareness of the role of the company secretary in today's corporate world. through the study circle meetings, seminars, webinars, and he is also primarily known as the orator and associates as the guest speaker, various student and member orientation programs organized by the ICSI Ahmedabad, Vadodara, Rajkot, Bhopal, and chapter of the WSE. So, without giving the more time, I request today's speaker start your session because आज मैं अगर इनके लिए बोलने जाऊं तो आज पूरी शाम कम पड़ेगी because his profile is very long or we can say he's the शब्दों का भंडार है CS विनीत नागर सर. So thank you sir.
Thank you Abhishek ji.
Thank you.
Yeah, Vinit ji, please today's session you can start now. And विनीत जी के सेशन बहुत ही वंडरफुल होते हैं. हमने लॉकडाउन के दौरान भी बहुत सेशन किए थे इनके, तो बहुत ही अच्छा लगा था, बहुत ही अच्छा रिस्पांस था सारे अटेंडीज का. नाउ ओवर टू विनीत जी.
Thank you very much, sir. Thank you.
Viraj ji, I will mute my video and audio. No?
Yes sir, yes sir.
Okay, thank you.
We can share the screen.
It's already there sir. You just put your presentation.
It is there. Is it visible?
Visible.
Is it visible? Screen is visible or not?
Screen is visible sir. You just put your presentation on screen. It will be visible sir.
The presentation is on, that's why.
Yes, we can see word file. Yes,
Presentation.
sir.
Yes, it's word file. That's right. So
Yes,
as far
sir.
as the scheme is concerned, I would like to say one good thing out of this pandemic is, as far as the defaulting companies are concerned, this is the scheme, that is fresh start scheme. Now the things what we need to take care of out of the scheme is, first of all, it's all about the scheme. That is what we need to discuss. The coverage of the scheme, that is applicability, non-applicability, that is the another things to take care of. There is again a general assumption in the mind of readers and the corporates that they will get immune from everything. So that is something to take care of, that the extent of immunity once a corporate opt for the scheme. Fourth thing is, certain companies for certain firms the scheme is not applicable to them, so that is one of the area of discussion. So these are the outline what we need to discuss. But as far as the topic of discussion is concerned, many of the companies which has been struck off, probably they were operating, but just because of the non-filing of financial statement and annual return, the registrar has presumed that company is not carrying any business, and the registrar in the name of shell company, they have closed many such non-shell companies. So it is a good time for them to get revived, to get their name restored on the records, and to get the best benefit of the scheme. And as far as the way through which an appeal or application can be made before the NCLT in order to get the company's name restored, these are the 6 things to take care of. I would like to go one by one. As far as the scheme is concerned, people used to forward so many WhatsApp messages, and outline can easily be identified from that messages only. So I don't want to go much into the scheme, but yes, the coverage, immunity, non-applicability, strike of companies, restoration, and the manner of filing of appeal, that is going to the area of discussion. In the March 24th, not too good day for many insolvency professionals, not too good day for the corporate, you can say the corporate debtor which is undergoing CIRP, that is second thing. But many of the operational creditor, they have got the announcement on 24th March, that is with regards to enhancement in limit of the IBC from 1 lakh to 1 CR. So not too good day for many of the operational creditor, not too good day for many micro small enterprises, not too good day for the bank, not too good day for the financial institution. But yes, it is one of the good day for many of the defaulting companies. 24th March, a general circular 11/2020 hint इसने दे दिया था. The scheme has come out with a specific immunity with this paragraph that no additional fees shall be charged for late filing during the moratorium period. So this is one of the opportunity, and I would like to say this is not an opportunity which is going to come again कोविड फिर से आ जाने के बाद भी ये स्कीम फिर से नहीं आने वाला, because one time opportunity somewhere prescribed in the very first page of that scheme. This is the last opportunity, or you may call it the first opportunity. In the past year 2010, there was a scheme, company law settlement scheme, but it was not that high waiver. 25% of the additional fees was still required to be paid at that time. But as far as this scheme is concerned, it has clearly stated that no additional fees shall be charged for late filing during the moratorium period. That is 1st April to 30th of September. Extension ho gaya nahi, that is second point. But as far as today is concerned, many of the NCLTs are virtually working, but they are not accepting physical application. In that manner, many of the companies, many of the promoter, they want their company to get restored, but their matter is not getting listed before the NCLT. So in that sense, I don't know whether the scheme will get extended or not, but up to this, as far as the scheme is concerned, that is applicable till 30th of September. In respect of any document, return, statement, etc., that means ministry has come out with 70-80 forms. There is a forms pertaining to the Companies Act 1956. For LLP also, the scheme is still inactive. As far as the Companies Act 2013 is concerned, there are 54 or 56 odd forms for which the scheme is applicable. So there are around 78 forms for which the said scheme can be opted for, but this scheme is only lasted up to 30th of September 2020. But one of the good statement is, it is required to be filed in MCA 21 irrespective of its due date. So whether any compliance lapse has been made in the year 2004 or 2014 or in the year 2019, you are now eligible to make that offense good by filing that particular form or return within the stated time frame of the scheme in nominal fees rather than additional filing fees. Now, as far as the General Circular number 12 of 2020 is concerned, the scheme was introduced by the ministry, and as far as the scheme is concerned, para 7 of the scheme is very important, because of which a person should opt for the scheme. If you see para 7 of the scheme, it clearly states that the registrar shall take necessary action under the act against the company who have not availed the scheme and are in default in filing this document in a timely manner. Meaning thereby, on expiry of the said scheme, ROC do have power under section 206. They can call for the information. Under section 207, inquiries and inspection by the order of the ministry, they may initiate action if the defaulting company is persisting after 30th of September 2020. Because I've seen many of the companies for which we have opted for the restoration. They have prepared their budget in the mind कि 5 लाख रुपए 6 लाख रुपए overdue filing का लगेगा. Now they people are completing their overdue filing just in 15,000 rupees or 25,000 rupees. So as far as the comparison is concerned, they are saving a huge quantum of fee in terms of the additional fees. As far as the coverage is concerned, I said para 7 of the scheme clearly states that this is the one time, this is the last time scheme, and on expiry of the said scheme, the defaulting company will not be in the safe haven. If you see para 7, it is clearly states that the registrar, being the adjudicating authority, shall take the necessary action under the act against the company who have not availed the scheme and are in default in filing this document in a timely manner. Timely manner means the time frame provided under the scheme. Disregarding the fact, वो फॉर्म जो आपको फाइल करना था in the year 2015, in the year 2016, by the scheme everything will get disregarded, but in a time bound manner. Is a time manner provided in the scheme, the time frame provided in the scheme, that is 1st April to 30th of September. If you are filing it, you will get immune from the prosecution. No prosecution will be initiated. No adjudicating authority will come to you by show cause notice for the adjudication of that offense. But as far as the one who are not going to avail the scheme after 30th of September 2020, ROC is free to initiate any action as far as section 454 is concerned. As far as the companies are concerned, the scheme is applicable to the company, both the companies, whether registered under the Companies Act or previous Companies Act. And yes, the scheme also applies to foreign companies which are carrying on any business operations in India, having place of business in India, or conduct any business activities in India. So whatever non-filing has been committed by them, FC1, FC2, FC3, the forms are under the ambit of the scheme. So this scheme also applies to a foreign company. As far as the company under CIRP is concerned, on admission of the CIRP under section 7 or under section 9 or under section 10 of the IBC, it's the insolvency professional who is duty bound to comply with the requirement of the act. He has to intimate the registrar of companies by filing form INC 28 so that the status of the company under the Ministry of Corporate Affairs portal can change from active to under CIRP, and thereafter all the normal compliances are required to be complied by this person who will be considered as a insolvency resolution professional who generally act as a IRP or RP during the process of CIRP. So this companies who are still live, no order of liquidation has been passed against them, if the company is active, they are still eligible to avail the benefit of the scheme. As far as the precondition is concerned, the company has to be an active company. The company has to be an active company. In spite of this fact, they are defaulters. There is a defaulting company, but defaulting company, in case if that company is active, the scheme can very well availed by them. But in case if the status of the company has been marked as struck off, in order to avail the scheme, you are bound to appeal under section 252(1) before the National Company Law Tribunal, or else you can make an application under section 252 subsection 3 in order to get the company's name restored on the records. Only after the status will get changed, you are eligible to avail the benefit of scheme, otherwise not. So as far as the forms are concerned, though I'm not considering LLP settlement scheme during this discussion, consider there are 78 odd forms for which the scheme is applicable. I don't want to discuss each and every form, but yes, as far as the Companies Act 1956 is concerned, there are around 10 forms which pertains to the 1956 Act with regards to filing of financial statement, annual return, appointment of statutory auditor, compliance certificate. So all the overdue forms which was not filed at that time, the companies are eligible to file such forms during the tenure of the scheme. Even though they are eligible to file after the tenure of the scheme, but they will not get immune from that additional fees. There are certain forms pertaining to the Companies Act 2013, 56 or 57 odd forms which pertains to Companies Act 2013, and companies are eligible to file. That is one common question which I've seen from many of the practicing professionals, whether MGT 14, which is required to be filed under 117, whether it is a part of this particular form or not. I must say yes, MGT 14 is forming a part of this particular e-forms introduced by the ministry. It is 45th number form, filing of resolution and agreement to the registrar. Under section 117, read with section 179 subsection 3, this MGT 14 is required to be now filed within 30 days. Earlier it was required to be filed within 300 days. Now if company wants to file it, but in case if the 300 days have been expired, they have to get their delay condoned from the ministry. Otherwise, there is no way this form can be filed. Now, as far as the application for immunity certificate is concerned, the one who has availed the scheme up to 30th of September 2020, once all the overdue forms have been filed, you have to make an application in form CFSS 2020. This form is not right now on the ministry's portal, but on expiry of the scheme, the e-form will be introduced by the ministry, and the validity up to which the form can be filed is up to 6 months from the expiry of the scheme. The scheme is going to expire on 30th of September 2020, meaning thereby up to 31st March 2021, a company has to make an application to the registrar by filing form CFSS in order to avail the immunity certificate. Now, as far as the immunity is concerned, you will be immune. You will get immune from launching of prosecution or proceedings for imposing penalty on the company with respect to filing of belated documents. Application money mangwa ke rakha hai. Section 42 subsection 6 ka कहना है that application money pe company has to make the allotment within 60 days. There is section 42, read with section 39 subsection 4, that when you allot, you need to file the return of allotment. Now, in case if company has failed to file return of allotment within the stated time frame of 15 or 30 days, as the case may be, you can avail the scheme by filing form PS3 and you will be immune from additional filing fees. But in case If the application money is standing, allotment has not been made after 60 days, on receipt of application money within 60 days, you have to make an allotment. If company fails to make an allotment on expiry of 60th day, within 15 days, company has to refund, otherwise it will be treated as a deposit. Now for that contravention, you will not get immune. So this scheme has not immuned the company from the non-compliances of the provision of Act. The immunity will be limited for the launching of prosecution or proceeding for imposing penalty on company with respect to filing of belated document. अगर कोई फॉर्म stated time frame में अगर फाइल नहीं हुआ है, you may file it within the tenure of the scheme. From what thing you will get immune? Delayed filing पे जो penalty act ने impose किया है, for that the ROC is not going to launch a prosecution, or ROC will not issue you show cause notice for the adjudication of the offences. From that part, you will get immune. But for any contravention under the provision of the Act, there is no immunity which can be availed. It is provided the immunity to be given only for those forms filed under the scheme and not for any previously filed forms. Now, I can't claim immunity. The scheme has been made effective from 1st April. Some belated form was filed in the month of January 2020 when the scheme was not introduced by the ministry. For those delayed filing, if ROC wants to initiate any prosecution, if ROC wants to prosecute the company and its officer in default, I cannot take the shelter of the scheme because those forms have not been filed during the tenure of the scheme. As far as the immunity form is concerned, or form in order to claim the immunity certificate is concerned, that is form CFSS 2020. One board resolution is required to be attached along with this form, whereas the board will authorize any of the director in case if company is having a KMP, then CEO or CFO or CS to make an application to the registrar by digitally signing that form. So board resolution is going to be the mandatory attachment along with that form CFSS 2020. Not only this, in case if ROC has initiated any action against the company, against which if the appeal has been filed under section 454 subsection 6, adjudicating authority, in case if they pass an order and impose a penalty, the appeal can be preferred before the regional director. There are 7 RD in the India. रीजनल डायरेक्टर की बात करूं तो आरडी ऑफिसेस 7 हैं भारत में, और जुरिस्डिक्शन के मुताबिक ऑर्डर की कॉपी मिलने के 60 डेज में यू हैव टू अपील बिफोर द रीजनल डायरेक्टर. इन केस इफ द अपील इज पेंडिंग बिफोर द आरडी, देन you have to withdraw that appeal. And in case if prosecution is pending before the court of law, then in that case you have to give the details with regards to that prosecution, if that prosecution pertains to the delayed filing. I would like to say, in order to claim the immunity certificate, you have to file form CFSS 2020, and with that particular form, you have to attach a copy of the board resolution where the board of directors have authorized any of the director. If company is falling under section 203 subsection 1, then board will authorize either CFO or CS or CEO to digitally sign that CFSS to make an application to ROC in order to claim that immunity certificate. And I said you will get immune only from the launching of the prosecution or proceedings for imposing penalty on the companies with respect to the delayed filing. But you cannot claim the prosecution, you cannot avoid the prosecution for any non-compliances under the provision of the Act which has affected public policy, which has impacted the stakeholder interest, which has impacted the creditor's interest. From that particular non-compliances, you will not get immune. And I would like to say, you can claim immunity certificate, or you will get immune only from those prosecution, those proceedings with regards to delayed filing, the filing which has been made during the tenure of the scheme, not for those forms which was filed prior to the introduction of the scheme. And as far as the form is concerned, you have to give a declaration. You have to give a declaration that an application for immunity certificate, whenever you make an application for, you have to give a declaration that no petition or appeal was filed against any notice issued or complaint filed before the court or NCLT or NCLAT or RD. In case if any action has been initiated by the ROC against which you have filed an appeal, In that case, you have to withdraw that appeal. You have to withdraw that appeal, because if that appeal is pending, you cannot simultaneously claim the immunity. So in case if any action has been initiated by the registrar, and against that, if some appeal has been preferred before the regional director or NCLT or NCLAT or before some court, in that case, you have to withdraw that particular appeal at the time of claiming this immunity certificate. So this declaration is mandatory. And as far as the attachment is concerned, it is provided that the attachment to the form CFSS, only 2 documents are required along with the board resolution. The one is proof of withdrawal of appeal, if any, filed by the company against the notice issued or complaint filed or an order passed by court or adjudicating authority under the act. As far as the adjudicating authority under IBC is concerned, it is NCLT, but I am talking about the adjudicating authority under the Companies Act, that is the registrar of companies. And one more thing, details in respect of the prosecution pending against the company or its officer in respect of such belated document filed under the scheme which require withdrawal by the registrar. So either if appeal has been made, if appeal has been preferred by the company, then you have to withdraw that appeal. And if the ROC has taken action, if ROC has prosecuted company, then you have to state the fact that this is a prosecution pending against a company and officer with respect to the belated documents filed under the scheme. And in that case, ROC will withdraw that particular prosecution also. So as far as the extent of immunity is concerned, that is what I was discussing since long. You will only get immune from prosecution or proceeding which pertains to any delay associated with filing of belated documents in the registry. I said immunity is only for the limited purpose, and immunity is not for, immunity will not from any action which has been initiated by the regulator, or any action which is proposed to be initiated by the regulator for the non-compliances under the provision of the act. This is what I stated, that you will get immune from such prosecution or the proceedings pertains to any delay associated with filing of belated document in the registry. काफी केस में stated time frame के अंदर आप फाइल नहीं करते हैं, for that whatever penal provision is there in the act, if it is pertaining to the fine, then again prosecution will be there. If it is pertaining to the penalty, then in that case, with the adjudicating authority, you may adjudicate that offense. So as far as delayed filing is concerned, any prosecution wherein the delayed filing is the question, then in that case you will get the immunity for that limited purpose. But in that case, some wrongdoings or misdeed or any other non-compliances committed under the act, for example, एनुअल जनरल मीटिंग के 30 दिनों में आरओसी के साथ फाइनेंशियल स्टेटमेंट फाइल करना है, as provided under section 137 of the Companies Act. Section 92 has provided that you need to file the annual return within 60 days. In case if that has not been filed within the specified time frame, and you are filing during the concurrency of the scheme for any such non-compliances of not filing the particular financial statement or annual return within the stated time frame, whatever is the consequences, you will get immune from them, but you will not get immune from calling up of an AGM after its due date. Misstatement in the annual return, आप annual return within 60 days of date of annual general meeting आप नहीं फाइल कर रहे हैं, and after certain year, just because of the scheme has been introduced by ministry, इस scheme के दौरान अगर आप annual return फाइल कर रहे हैं, तो जो आपने delay से फाइल किया, for that you will not be prosecuted. And if any prosecution has been initiated, ROC will withdraw it also. But make sure it is a prosecution pertaining to the delayed filing. But in case if there is any misstatement in the annual return, in case if the annual general meeting has not been called within the stated time frame provided under section 96, in that case, or in case if the fund has been raised, but there is a misapplication of the fund, or there is something which is in contravention of the provision of act, in that case, for the non-compliances committed under the act, whereas there is a stakeholder interest is at stake, the creditor interest is at stake, the government interest is at stake, for that you will not get immune. As far as the immunity shall not be applicable in the matter of the appeal pending before the court in case of mismanagement. I've seen many of the companies, 397, 398 of the old act, under the current Act, Companies Act 2013, Section 241, Section 242. Just because of the management dispute, a dispute is going on. An appeal has been, an application has been made before the National Company Law Tribunal under Section 241. And because of that, application is pending before the NCLT. Some filing is overdue, because in operation mismanagement matter, I've seen many of the time, director को गलती से निकाल दिया, further shares allot की, existing shareholders को right नहीं दिया, एक group ने अपना holding increase कर दिया, so that no professional would like to certify that form, whereas the list of shareholder is already in dispute. अगर ऐसा कोई reason है, ऐसा कोई कारण है, mismanagement का matter pending है, earlier before CLB, now matter has been transferred to NCLT. In that case, अगर filing नहीं हुआ है और वो filing अगर ये scheme के दौरान अगर कर रहे हैं, for that they will not get immune. I said they will not get any such kind of waiver. So immunity shall not be applicable in the matter of any appeal pending before the court of law, and in case of management dispute pending before the court or the tribunal. As far as no immunity shall be provided in case the court has ordered the collection in any matter, or an order imposed a penalty has been passed by the ROC, but no appeal has been preferred against such order of the ROC. As far as the prosecution is concerned, or as far as the adjudication is concerned, ROC has already imposed a penalty. You are bound to file, you are bound to pay the penalty. If no penalty has been made or no appeal has been preferred, in that case also you will not get any kind of immunity in case if appeal has not been preferred by the company. Now again, there is again a misconception in the mind of many professionals that by availing the scheme, you can able to file all the related documents and return during the tenure of the scheme, and on the completion of the scheme, when you will file Form CFSS 2020, in order to get the immunity certificate, your disqualification will get removed. Mark my words, under the Companies Act 2013. Under the Companies Act 2013, there is not a single section which talks about removal of disqualification of director. There was a scheme introduced in the year 2018, and that was condonation of delay scheme. In that scheme, the power has been given to the National Company Law Tribunal for only those companies for which a specific prayer was preferred before the NCLT. ऐसी कंपनी जो उस दौरान एक्टिव थी but directors disqualified थे, या ऐसी कंपनी जो उस समय स्ट्रक ऑफ हो गई और NCLT के ऑर्डर की तहत जिसका डिस्क्वालिफिकेशन रिमूव हुआ और उसका भी आखिरी दिन था somewhere in the May 2018, 17th May 2018 का एक सर्कुलर था जिसने क्लियर कर दिया था दैट डिस्क्वालिफिकेशन NCLT उन्हीं कंपनीज का हटाएगा जो पिटिशंस फाइल हुई ड्यूरिंग द concurrence of that scheme, CODS scheme. Otherwise, in the Companies Act, many professionals are presuming that after availing the scheme, the disqualification will get automatically wiped off, the disqualification will get removed. No, this scheme has nothing to do with disqualifications of the directors of the company. If you want to avail the scheme, I've seen many of the active companies, in spite of non-filing since years, the status of the company is still active. The reason is the charge is standing in the index of charge. काफी ऐसी कंपनीज हैं जिनका पिछले सालों का फाइलिंग नहीं हुआ है. The directors have been disqualified because directors disqualification is there under 164 subsection 2 clause A. अगर आपने पिछले 3 सालों से अगर कंपनी ने ROC के साथ फाइनेंशियल स्टेटमेंट या एनुअल रिटर्न फाइल नहीं किया, the director will be marked disqualified, but company is still active. And there is no logic or there is no magic behind it. The only logic is ROC, considering the interest of that secured creditor, has not struck off the company's name. In case if the directors are disqualified and if somebody wants to avail the scheme, 167 subsection 3, that all the directors have been disqualified, you have to appoint a new director. The promoter will appoint the new director. The appointment of new director by the promoter shall be ratified by the shareholder, and there will be back-end entry. ROC and RD will be the authority who will facilitate you to appoint a new director on the board, and only after appointment of new director you can avail the benefit of the scheme. Otherwise, the disqualified director on the board of active company My words are, the disqualified director on the board of active companies are not eligible to avail the scheme, because by the provision of Act 167(1)(a), if the directors have been disqualified, they have to vacate the office. And if the director is disqualified, he is having no locus who will be able to digitally sign that form, even though that scheme is in motion. For that, the promoter meeting has to be scheduled. The promoter will appoint a new director. In case if all the directors have been disqualified, the promoter, those director which has been appointed by the promoter, the thing has been placed before, the agenda has to be placed before the shareholder in the extraordinary general meeting or the AGM, as the case may be, and the shareholder who will ratify the resolution passed by the promoter, and then you have to make a physical application under 167 subsection 3 to the ROC, and ROC and RD shall facilitate with the digital signature of the regional director. One director will be added to the signatory, and with that director sign, the other directors will be appointed. And only once your directors are a qualified director, eligible director, qualified director, only they are eligible to file all the belated form in order to avail the benefit of the scheme. So the scheme shall not remove the disqualification of director. So this is one of the presumption or assumption of the people, but having no reality with the scheme. As far as this is one of the important thing, if the registrar has already launched a prosecution against the company can still file the forms, returns or belated documents under the scheme, but immunity is not given against such prosecution. Make sure if the prosecution is for some other purpose, the prosecution is with regards to misutilization of the shareholders' money. If the prosecution is with regards to non-calling up of an AGM, that prosecution shall not be withdrawn. The prosecution shall continue as per the process of law. The scheme shall not release the company or its officer from violation of the provision of the section. It shall only absolve only from the penalty or prosecution which with respect to filing of document under the scheme. So any belated document if you are filing, and just because of this purpose, belated filing of the document, if ROC has initiated any prosecution, ROC shall withdraw the prosecution. Otherwise, no prosecution shall be withdrawn which is having no nexus with the belated filing. Now, some wrongdoers cannot get the immunity. Vanishing companies, some wrongdoers shall not get immune. This is para number 6, point number 9, clause E of the scheme. As far as the vanishing companies means, vanishing companies को स्पेसिफाई किया है अंडर चैप्टर 18 ऑफ द कंपनीज एक्ट 2013, जहां पे हम लोग स्ट्राइकिंग ऑफ के प्रोविजन देखते हैं 248 टू सेक्शन 252 रूल्स में इसको डिफाइन किया है वैनिशिंग कंपनीज को. ऐसी कंपनीज जो कि इनकॉर्पोरेट हुई है अंडर द कंपनीज एक्ट 2013 और अंडर प्रीवियस एक्ट. One more thing, listed with the stock exchange but has failed to file the returns with the ROC and stock exchange for consecutive 2 years. Either a company is incorporated in this act or the previous act, listed with the stock exchange but has not filed any returns, statutory, mandatory returns, quarterly, half yearly, annual returns for last 2 consecutive financial year, is not maintaining its registered office as notified in the ROC record or stock exchange record. तो ROC के या stock exchange के records पे जो उसका एड्रेस है, ऐसे एड्रेस पे कोई registered office है ही नहीं और उसके directors traceable नहीं है. I said how this company can avail the scheme, because in order to avail the scheme, the company's board should be traceable first of all. और ये vanishing companies की वजह से ही section 12 subsection 9 इनेक्ट हुआ 2 नवंबर 2018 को, जहां पे ROC को पावर दिया to physically verify the registered office. और लास्ट ईयर शायद इट वाज INC 22A was introduced by the ministry, जहां पे लोकेशन स्पेसिफाई करना था. कंपनी की रजिस्टर्ड ऑफिस का फोटोग्राफ अपलोड किया मिनिस्ट्री के साथ, जैसे डायरेक्टर्स के KYC चेक हुए, कंपनीज के KYC चेक हुए, जस्ट बिकॉज ऑफ दिस वैनिशिंग कंपनीज. बेंगलोर का इंसिडेंट है जहां पे एक ही प्रेमाइसेस पे मल्टीपल कंपनी की रजिस्टर्ड ऑफिस हुआ करती थी, या फिर एक प्रेमाइसेस जिसका सिर्फ एड्रेस स्टॉक एक्सचेंज के रिकॉर्ड्स में था या कंपनी के रिकॉर्ड्स में था, बट ऐसा कोई प्रेमाइसेस वर्चुअली अगर देखा जाए या फिजिकली देखा जाए तो it was not in existence even. And because of that, so many provisions have been introduced under section 12. And under section 12 subsection 9, the power has been given to the registrar, whereas ROC can physically verify the registered office of the company. And this generally happens. I've seen many of the in many of the times shifting of registered office, order passed by RD, order has been dispatched to physical through registered post at the company's address, but address पे कोई claim करने वाला है ही नहीं और वो unclaimed वापस ROC की office में आ रहा है. Some RD has passed an order with regards to conversion of company. RD has passed an order with regards to compounding. Order has been physically dispatched through registered post, but nobody is claiming it. And unclaimed document returned back to the regional director. In that case, RD generally empower ROC, give a direction to ROC to initiate action under section 12. So you have to maintain the registered office. And in case if company is a vanishing company, they are not in a position to avail the benefit of the scheme, and the vanishing companies are basically the company registered under the act, under this act or under previous act, जिसने पिछले 2 सालों से ROC के रिटर्न्स और स्टॉक एक्सचेंज के साथ जो मैंडेटरी कंप्लायंसेस हैं वो नहीं किए हैं. Such companies not even maintaining its registered office at the address which is notified in the records of ROC and the stock exchange, and the directors of such companies are not traceable. This vanishing companies will not be in a position to avail the benefit of the scheme. Scheme shall not apply. The scheme shall not apply where the final notice of the striking off under section 248(4) has already been initiated by a designating authority. Designated authority is ROC. Generally, ROC क्या करता है? Final notice, either you can make an application under 248(1) or else you can make an application under section 248(2). 248(1) में जो आप application करते हैं, सही 248(1) में जो एक्शन की बात करूं तो ये एक्शन ROC लेता है. Under section 248(1), the action initiated by the registrar, whereas under 248 subsection 2, it is a voluntary application which is always preferred by the company. ऐसे circumstances में जब ROC ने एक्शन लिया है, ROC used to issue notice, and notice generally issued at the registered office of the company and also at the address of the director. 248 की वो जो नोटिस है, उस नोटिस का जवाब 30 दिन में देना होता है. ROC वो जब नोटिस इशू करता है, ROC used to specify the grounds of issuing notice under 248(1), and the grounds is either the company has not commenced any business, either the company has not carried on any business since incorporation, or no business has been carried on in since last 2 preceding financial year. Either the company has failed to commence business from the very first day of its incorporation. If company has failed to commence any business within 1 year from the date of incorporation, or company is not carrying any business, or company is not carrying any business or operation since last 2 preceding financial year, in that circumstances, ROC issue a notice in फॉर्म STK1 जिसका जवाब 30 दिनों में देना है. अगर आपने वो 30 दिनों में जवाब नहीं दिया, then in that circumstances ROC दूसरी नोटिस इशू करेगा, and that will be in STK5. STK5 का जो नोटिस है वो मिनिस्ट्री की वेबसाइट के ऐसे MCA पोर्टल पे भी ये लोग अपलोड करते हैं. They also used to publish in the official gazette, and these things also get published in the newspaper. There is an English newspaper or a vernacular language newspaper in STK5A. STK5 का जो नोटिस होता है, that is the last opportunity. और ये जो नोटिस है वो रेगुलेटरी अथॉरिटी को भी दिया जाता है, that is income tax or central excise authorities, service tax authorities earlier, or having a jurisdiction over the company about the proposed action. ROC proposed action is under section 248(5). Proposed action is to strike off the company's name from its record. ऐसा एक्शन लेने से पहले ROC STK5 में एक नोटिस देता है, और 30 दिनों में अगर कोई ऑब्जेक्शन रेज ना करे, then ऐसे केस में 248(5) की तहत ROC ऐसी कंपनी का नाम रिकॉर्ड से भी हटाएगा, and the fact will be published in the newspaper as well as in gazette in STK7. तो ऐसी कंपनीज जिस कंपनीज के अगेंस्ट में ROC ने ये लेवल के एक्शन ले लिया है, the company against which an action for final notice, and the final notice is generally issued under 248 subsection 4. The company against which the action for final notice for striking of the name under 248 subsection 4 of the act has been issued by the ROC. In that case, you will not be in a position to avail the benefit of the scheme. I've seen many of the times. मेरे ही केस में हुआ था, मैं बात कर रहा हूं prior to COVID. The status of the company was not strike off. The status of the company was under the process of striking off, and this was not a voluntary application made by the company. It was the action already initiated by the registrar. And when I approached the ROC office, when I approached NCLT. NCLT कहता है कि we are not going to accept application जब तक कंपनी का स्टेटस स्ट्राइक ऑफ नहीं आ जाता, और ROC कहता है कि action has been initiated by us. Now there is no way through which the action can be again taken back. So for such companies, the scheme does not apply. Secondly, where any application has already been filed by the company for an action for striking of the name of the company from the register of company. Now this indicates a voluntary application made by company and so either of the case, if the final notice has been issued by the ROC, final notice issue किया जाता है STK 5 में, ROC अपने रिकॉर्ड से, every registrar of companies do maintain a register of company. This is section 2 subsection 74 and section 2 subsection 75. ROC रिकॉर्ड से नाम हटाने से पहले फाइनल नोटिस देगा STK 5 में, और ये नोटिस जो ऑफिशियल गैजेट में पब्लिश होगा, वेब पोर्टल पे आ जाएगा मिनिस्ट्री के, न्यूज़पेपर में पब्लिश होगा, न्यूज़पेपर में पब्लिश होगा इन फॉर्मेट STK 5A. अगर वो नोटिस पब्लिश हो चुका है, इनकम टैक्स अथॉरिटीज को, गवर्नमेंट अथॉरिटीज को वो नोटिस चला गया है, इन दैट केस इसका मतलब ये हो गया कि एक्शन हैज बीन इनिशिएटेड, या फिर कंपनी ने वॉलंटरी एप्लीकेशन किया है, यू कैन नॉट अवेल द स्कीम. वन मोर थिंग टू बी टेकन केयर ऑफ, द कंपनी व्हिच हैज बीन अमालगमेटेड अंडर द स्कीम ऑफ अरेंजमेंट और कॉम्प्रोमाइज अंडर द एक्ट, section 230, read with section 232. If the compromise or arrangement has been made, this is the dissolution of the transferor company without the winding up. So when your transferor company is not in existence, there is no way you can go back to the past and can comply with the overdue filing, or some scheme is pending before the tribunal. In that case, I cannot avail the benefit of the scheme. One more thing, the company who has availed the status of dormant, once a company has availed the status of dormant under section 455 of the Companies Act, I said if the company has availed the status of dormant under section 455 of the Companies Act prior to the enactment of the scheme, prior to the commencement of the scheme, for this company also the scheme shall not be applicable and vanishing company, as we have discussed in the earlier point. And one more thing, the scheme has excluded certain forms, asset 7 specifically for increase in authorized share capital and charge oriented document, that is CHG1, what we used to file for registration of creation of charge, CHG1 for the registration of modification of charge, CHG9 for registration of creation or modification of charge in favor of debenture holder, and CHG4 under section 82 for satisfaction of charge. For such form, the said scheme does not apply. Now, as far as the restoration of stuck off companies are concerned, I would like to say the benefit of the scheme can only be availed by an active company. If a company's status has been marked as struck off, if you want to avail the scheme, first requirement is, or the foremost requirement is, the company is having an active status on the MCA portal. But if the status of the company has been marked as struck off, there is only option available is you should go before the NCLT and get your company's name restored. Now, I would like to categorize company in three parts. One company, I said I would like to categorize companies in three parts. मैं उन companies की बात कर रहा हूं जो strike off हो चुकी है, जिसका नाम ROC ने अपने रिकॉर्ड से रिमूव कर दिया है. इन कंपनीज को I would like to विभाजित करना चाहूंगा. I would like to categorize into three parts. The first part is, कुछ ऐसी कंपनीज भी हैं जो सही में इनएक्टिव थी, जो कंपनी ने सही में कोई बिजनेस नहीं किया, ऐसी कंपनी के अंदर कुछ ऑपरेशंस थे ही नहीं, और ऐसी कंपनी का नाम ROC ने सुओ मोटो स्ट्रक ऑफ किया. दूसरा, कुछ ऐसी कंपनीज जिसमें कुछ ऑपरेशंस रहे होंगे, उस कंपनी के नाम पे कोई प्लांट, कोई लैंड, कोई बिल्डिंग, कुछ रिसोर्सेस कंपनी के नाम पे होंगे. वो भी कंपनी तो वही होंगी जिन्होंने कोई बिजनेस किया था, बट जब ROC ने स्टक ऑफ किया उस समय कंपनी में कोई बिजनेस नहीं था. और तीसरी वो कैटेगरी की बात कर रहा हूं जिस कंपनी में बिजनेस तो था, जो कंपनी ऑपरेटिव भी थी, बट कहीं ना कहीं से बिकॉज ऑफ सम कम्युनिकेशन गैप, बिकॉज ऑफ सम अंडरस्टैंडिंग इश्यूज, because of some no clarity in the mind of the entrepreneurs, because generally board of directors are least aware with regards to who is taking care of their filing portion, who is taking care of compliance portion. I am connected with several chartered accountants. I'm associated with them since years. I'm doing all the compliances on behalf of their companies, their client companies, but the directors are not aware that it's a Vinit who is taking care of all the compliances part. In case if some dispute arises between me and that chartered accountant, and in that dispute, some miscommunication was there. Chartered accountant was presuming that it's Vinit who will take care of the compliances part in spite of departure of relationship. And the director is presuming that it's a chartered accountant who is taking care of all the compliances. And just because of this fight, just because of this misunderstanding, the filing got lapsed and ROC has struck off a operating company. मैं तो कहना चाहूंगा ये section जो है, I would like to put my point on this topic. NCLT restoration का order पास करने से पहले जब बैंक स्टेटमेंट मांगती है, NCLT इनकम टैक्स का रिप्रेजेंटेशन मांगती है, तो RO से सिर्फ नॉन फाइलिंग की वजह से, जस्ट बिकॉज ऑफ द नॉन फाइलिंग ऑफ फाइनेंशियल स्टेटमेंट एनुअल रिटर्न ऑफ प्रीसीडिंग ईयर, हाउ कम ROC presume that company is non-operative? Why ROC don't? Why ROC? When ROC close the company, ROC कंपनी का नाम अपने रिकॉर्ड से हटाने से पहले 10 प्रिकॉशन रखती है. पब्लिक नोटिस देना, गैजेट में पब्लिश करना, MCA पोर्टल पे अपलोड करना, so that just for the sake of an invitation of representation, कि किसी को इस कंपनी के बंद होने से ऑब्जेक्शन तो नहीं है. तो ROC ये जो एक्शन लेती है, what I feel is ROC generally presume that if the filing has not been done, if company has not filed its financial statement and annual return, then it is always presumed by the registrar office that company is non-operative or not carrying on its business. और ऐसे केस में ROC ऐसी कंपनी का नाम स्ट्राइक ऑफ कर देती है. Now here I would like to say, now it's a topic of discussion right now. क्यों ऐसी कंपनी को इस स्कीम का पूरा फायदा उठाना चाहिए? मैंने जो 3 कैटेगरीज की कंपनी बताई जिनका नाम ROC के रिकॉर्ड से स्ट्रक ऑफ हो गया है, the name of which has been struck off from the records of ROC. I said there are certain non-operative companies, there are certain non-operative inactive companies जो सही में उन्होंने कभी बिजनेस किया नहीं, and just because of that purpose the filing was not done and the ROC has struck off such companies name. The another category is उन्होंने कभी अपना बिजनेस किया था, somewhere in the past they have commenced their business operation, they were carrying on their business operation, but in past few years the operation was not there in the company, but some asset was there in the name of the company, some plant was there, some asset was there, some land was there, some bank account is there, some balance was there in the account. और तीसरा वो कंपनीज की बात कर रहा हूं जिनका स्टेटस तो ROC के रिकॉर्ड से स्ट्राइक ऑफ है, but they were carrying their business operation at the time when ROC has struck off the company's name from its records. उनको पता कब चला? जब मिनिस्ट्री के डायरेक्शन पे उनके बैंक अकाउंट फ्रीज हो गए. उन्हें पता कब चला? जब उनके प्रोफेशनल कुछ फॉर्म फाइल करने बैठे और देखा तो स्टेटस स्ट्राइक ऑफ था. उन्हें पता कब चला? जब पता चला कि they want to sell out some land or they want to purchase some machinery, but when company is no more in its active status, this thing comes to a standstill condition. और ऐसे circumstances में काफी restoration की अपील हुई, काफी restoration की application हुई. तो I would like to say कि क्यों ये स्कीम का बेनिफिट उठाना चाहिए इन तीनों कैटेगरीज की कंपनीज को, because now the filing fees is something which can be counted on figure. It's not too high. There was a time prior to the enactment of scheme, there was a time prior to the introduction of the scheme when filing fees was so hefty. शादी के खर्चे से भी ज्यादा annual filing का बजट बनाना था. But as far as this scheme is concerned, I would like to say filing fees is ranging in thousands, not even in lakh. Why all 3 category of company should opt for the restoration? My first reason is the liability of every director and officer shall continue and can be enforced for discharging the liability of the obligation of the company. Meaning that I would like to say, even though ऐसी कंपनी का present status strike off है, but director या officer की liability आज भी खड़ी हुई है और वो liability आने वाले सालों साल तक वो खड़ी हुई रहेगी. If you see section 248(7), I said I do have some reasons. मेरे पास वो कारण हैं जिसकी वजह से मुझे लगता है कि all 3 category of struck off company should avail the scheme at a cost of few thousands of rupees in order to avoid lack of rupees in prosecution, lack of rupees in penalties. I would like to say section 248 subsection 7, if it can be witnessed, the liability, if any, of every director. Very important provision of the Companies Act. The liability, if any, of every director, manager, or other officer who was exercising any power of the management, and of every member of the company dissolved under the subsection 5 shall continue and may be enforced if the company had not been dissolved. This is one of the reasons I believe the company's name should be opted for restoration. आप restore करवाओ, scheme का benefit लो, file करो overdue returns, minus all your liabilities, minus all your future litigations, and close your venture. This will cost you some thousands of rupees, but you are going to safeguard your image. You are going to safeguard lakh of rupees tomorrow in case if the prosecution has been initiated. Section 248(7) is one of the reasons. I said the liability, if any, of every director, manager, or other officer who was exercising any power of the management, or every member of the company. Now, this is the lifting of corporate wheel. In case if I bring in between members, they are liable only for the amount of the share capital they have introduced. They are liable to pay the value of the share. But still, in case if any unpaid amount is there, for that even a member shall also be liable, even though the company's name has been dissolved. And if you see section 248(8), nothing in the section, that means even though the name of the company has been struck off, nothing in this section shall affect the power of the NCLT to wind up the name of the company which has been struck off from the records of the company. ROC ने उस company का नाम strike off कर दिया, या आपने misleading तरीके से application किया और ROC has processed the closure of your company. But tomorrow, in case if any creditor will approach tribunal, the company and liquidation order can be passed. Section 250 check कर सकते हैं, where the company stands dissolved under 248. It shall on and from the date mentioned in the notice under subsection 5, that is in STK 7. STK 7 के अंदर जो date है, उस date की बात हो रही है, cease to operate as a company, and the certificate of incorporation issued to it shall deem to have been cancelled from such date. आगे लिखा हुआ है, except for the purpose of realizing the amount due to the company and payment or discharge of the liability or obligation of the company. So कंपनी का नाम आरओसी के रिकॉर्ड से स्ट्रक ऑफ हो गया और प्रमोटर खुश हो गए कि हमको तो वैसे ही बंद करनी थी, आरओसी ने बंद कर दी, 10,000 रुपए फाइलिंग फीस का और प्रोफेशनल का फीस बच गया. सो आई वुड लाइक टू से ये खुशी कुछ महीनों की या कुछ सालों की हो सकती है, बट हमेशा के लिए नहीं. सो दिस इज वन ऑफ द रीजन दैट लायबिलिटी ऑफ एवरी डायरेक्टर एंड ऑफिसर shall continue and it can be enforced for discharging the liability and obligation of the company. Creditor of such company may initiate action with a view to recover that overdue sum with interest. आप देख सकते हैं section 252(1) में. It can be identified from section 252 subsection 1. Read with, or you can see 252 subsection 3. Even the creditor can also, the interest of creditor is not going to endanger even though the name of the company has been struck off. कोई सा भी dues जो outstanding था, as on the date जब ROC ने उस कंपनी का नाम स्टक ऑफ किया, वो क्रेडिटर इस ड्यू को लेके सेक्शन 252 सबसेक्शन 3 इन्वोक कर सकता है. No doubt within 20 years from the publication of the company's name in the official gazette, ROC ने जब उस कंपनी का नाम अपने रिकॉर्ड से हटाया और वो फैक्ट जब पब्लिश हुआ ऑफिशियल गैजेट में pursuant to section 248 subsection 5, उसके 20 साल के अंदर अंदर एक क्रेडिटर भी चाहे तो एप्लीकेशन इनिशिएट कर सकता है अंडर सेक्शन 252 सबसेक्शन 3, और अगर वो रिस्टोर हो गई तो अगेन वजीर या राजा जिंदा वाली जो बात है चेस की, आई वुड लाइक टू से थिंग्स विल बी द सेम एज फार एज द गेम ऑफ चेस इज कंसर्न्ड. अगेन आई वुड लाइक टू से द रजिस्ट्रार may also recommend prosecution of the persons responsible for non-filing of returns and document. I have seen and very sorry to say, but the professional themselves encourage many times. जब कोई client approach करता है कि we want to close this company, but still there are some revenues, there are some outstanding, but we as a professional used to say आप balance sheet नील करके दे दो and we will process for the closure. I would like to say how you can kneel your balance sheet just by accounting entries when actually the liability is outstanding. How you can write off such things which you cannot write off legally and just by certifying nil balance sheet, you close the company. But this will not solve the purpose. If you see section 251 subsection 1, if you see section 251 subsection 1, it is quite dangerous. Even though आपने voluntary application किया था, ROC ने आपकी कंपनी का नाम स्ट्रक ऑफ कर दिया, मैं तो फिर से कहूंगा, you should also advise such promoter जिन्होंने अगर इस intention से कंपनी का नाम स्ट्रक ऑफ किया है, the opportunity is still with them. They should get the company's name restored. They should make all the past incorrection correct, and they can thereafter close the company. If you see section 251(1), where it is found that an application by the company under subsection 2 of 248, this is a voluntary application, was made with an object of evading the liability or with an intention to deceive creditor or to defraud other person, the person in charge of the management of the company shall, notwithstanding that the company has been notified as a dissolved, even though the status of the company has been strike off, even though the company has been notified as a dissolved, आप successful prove हो गए, आपने voluntary application किया, but with an intention to evade the liability, intention to deceive the creditor, defraud some person, in that case, ROC के पास पूरा power है. ROC के पास power है to recommend the prosecution of the person responsible for filing an application, and in that case, the directors of the company shall be liable to that person who has incurred loss or damages as a result of the company being notified as a dissolved, and they shall be punishable under 447. That is a fraud. One more thing, disqualification. Disqualification. Now let me explain. 248 subsection 1, read with 164 subsection 2 clause A. ध्यान से सुनना. 248 subsection 1 versus, or read with, I would like to say versus 248 subsection 1 versus 164 subsection 2 clause है. ROC कब initiate कर सकता है action? If company has failed to commence business within a 1 year from the date of incorporation, or company is not carrying any business or operation since last 2 preceding financial year, but disqualified कब होंगे? जब पिछले 3 सालों से आपने फाइलिंग नहीं किया है. मैं कहूंगा दोनों चीज को कंपेयर करें. 2 सालों से फाइलिंग ना होने की वजह से आपकी कंपनी का नाम ROC के रिकॉर्ड से स्ट्रक ऑफ हो गया. मैंने तो ये केस बनाया हुआ केस है. 2 सालों का फाइलिंग ना होने की वजह से ROC has struck off the name of the company from the records of ROC. ROC has struck off the name from its record, but 3 साल पूरे नहीं हुए थे. 3 साल पूरे नहीं हुए थे, और काफी हद तक पता था कि अगर 3 साल हो गए और 3 सालों का फाइलिंग नहीं होना is a ground under the Companies Act 2013, 164 subsection 2 clause A, जिससे directors will be disqualified. उन 2 सालों के बाद इन 3 सालों के बीच में हम लोगों ने NCLT में पिटीशन लगाया. Even though Companies Act में disqualification removal का कोई power नहीं है, NCLT cannot remove any disqualification of director, but it was specifically prayed by us. It was specifically prayed by us in the appeal made under 252(1) in the year 2019. उस बीच हम लोगों ने एक रिलीफ मांगा था कि आज की तारीख में तो हमारे डायरेक्टर्स का इनएक्टिव है. आज की तारीख में हमारे डायरेक्टर्स आर नॉट डिस्क्वालिफाइड. As far as the list of disqualified director uploaded on the MCA portal, हमारे डायरेक्टर्स का नाम उस लिस्ट ऑफ डिस्क्वालिफाइड डायरेक्टर में नहीं है. बट इस रिस्टोरेशन के दौरान अगर हमारा नाम डिस्क्वालिफाई कर दिया गया, इस रिस्टोरेशन के बीच में NCLT जब तक ऑर्डर पास नहीं कर देता, उस बीच अगर हमारे डायरेक्टर्स का अगर डिन डीएक्टिव, हमारा डिन जो है, इफ इट हैज बीन मार्क्ड एज अ डिस्क्वालिफाइड, वी वांट अ सॉल्यूशन फ्रॉम योर ऑनर. वी वांट the tribunal to pass an appropriate order where the DIN should get activated and disqualification should get removed, and we successfully come out with this, we have got a result in our favor. तो मेरा यही कहना है, अगर आपका फाइलिंग नहीं हुआ है and if the company's name has been struck off but still 3 साल पूरे नहीं हुए, it's a good time, go before the NCLT, get the restoration order, avail the benefit of the scheme before the 3 years get expire, and safeguard your interest as a director. If you see 164 subsection 2, no person who has been director of the company which has not filed a financial statement or annual return for a continuous period of 3 years shall be eligible to be reappointed as a director of that company or appointed in another company for 5 years from the date on which the company fails to do so. That means it is also impacting your interest in other company, and you have to vet the board of several other blue chip companies. काफी अच्छी कंपनी के बोर्ड से आपको पोजीशन गंवानी पड़ेगी, provided that. And not only this, अगर ऐसी कंपनी में कोई नया डायरेक्टर भी आता है जिसने पिछले 2 सालों से फाइनेंशियल स्टेटमेंट या एनुअल रिटर्न फाइल नहीं किया, 6 महीना तक कायदा उसको देखेगा, 6 महीने के बाद नया डायरेक्टर भी डिस्क्वालीफाई हो जाएगा. I said provided that where a person is appointed as a director of the company which is in default of clause A or B, he shall not incur disqualification for a period of 6 months from the date of his appointment. So I would like to say this is also a reason such companies' names should get struck off. This is what I said. Disqualification ka impact, I have to vacate the board of all the other companies. So the office of director shall become vacant in case if he incurs any of the disqualification provided under 164. वो सिर्फ उसी कंपनी के बोर्ड में कंटिन्यू कर सकता है जिस कंपनी के अंदर वो डिफॉल्ट है, बाकी सभी कंपनी के बोर्ड से उसको वैकेट करना होगा. And not only this, I have to carry this tag of disqualification for next years. 5 साल के लिए डिस्क्वालिफिकेशन, बट 5 साल के बाद अगर कंपनी मुझे अपॉइंट करती है तो उस समय मुझे DIR 8 में वो डिस्क्लोजर देना होगा कि इन दिस कंपनीज आई वाज मार्क्ड डिस्क्वालिफाइड. एंड अगेन आई वुड लाइक टू से कंपनीज एक्ट में 5 साल का जो डिस्क्वालिफिकेशन है, बट 5 साल के बाद क्या होगा वो कंपनीज एक्ट में भी नहीं लिखा हुआ है. नो डाउट दैट इज वन फॉर्म DIR 10 which will straight away go to the ministry, but ministry जहां तक मुझे लगता है या जो भी मेरी एक लिमिटेड अंडरस्टैंडिंग है इस कायदे की, मेरा दिमाग ये कहता है कि आज 5 साल के बाद 2016 से 2021 तक अगर मैं डिस्क्वालिफाइड हूं, 2021 में जब मेरा डिस्क्वालिफिकेशन का टेन्योर खत्म होगा और जब मैं मिनिस्ट्री को एप्लीकेशन करूंगा इन DIR 10, क्या मिनिस्ट्री ये नहीं देखेगी फॉर व्हाट रीजन आई हैव बीन मार्क्ड डिस्क्वालिफाइड? और उस समय अगर मैं मिनिस्ट्री को बताऊंगा देयर वाज अ रीजन ऑफ डिस्क्वालिफिकेशन, देयर वाज अ कंपनी वेयर फाइलिंग वाज नॉट डन, the company's name was struck off. और अगर मैं कहूंगा we have opted for the restoration of the company's name during the concurrence of that scheme, CFSS scheme, during the tenure of that scheme, we have opted for the restoration. We have successfully restored the company's name. We have filed all the overdue documents and return, and today the company's name has been struck off again. हमने voluntary फिर से एप्लीकेशन कर दी उस कंपनी का नाम ROC की रिकॉर्ड से हटाने के लिए. उस समय अगर मैं बोनाफाइड शो करूंगा तो मुझे मिनिस्ट्री में ज्यादा प्लीड करने की जरूरत नहीं होगी. सो आई वुड लाइक टू से ये डिस्क्वालिफिकेशन जो 5 साल का है, 5 साल के बाद भी क्या डिस्क्वालिफिकेशन ऑटोमेटिक हटेगा, उसको लेके मेरा जो मानना है वो है नहीं. बिकॉज व्हेन यू विल मेक एन एप्लीकेशन टू द मिनिस्ट्री ऑफ कॉर्पोरेट अफेयर्स इन DIR 10, यू हैव टू शो on what grounds you have been marked as a disqualified and what is the status of that event. What is the status of that particular non-compliances due to which you have been marked as disqualified, whether the offense has been made good or not. And in case, if that offense has been made good, it shows your bona fide. And I feel at the end, it is a great scheme to opt for. It is a great scheme to opt for because in the scheme, you have nothing to lose except few thousands rupees and some professional fees. That's it. And at the end, I would like to discuss the final thing. If you want to file an appeal or application, हर NCLT का अलग-अलग व्यू पॉइंट है, बट जो मेरा व्यू पॉइंट है वो ये है, 252 सबसेक्शन 1 में जो होती है वो अपील है, एंड 252 सबसेक्शन 3 में जो करते हो वो आप एप्लीकेशन है. आप डिफेंसिव हैं, यू शुड गो विद एन एप्लीकेशन. जब सही में आपकी कंपनी ऑपरेटिव नहीं थी या सही में कंपनी में कोई ऑपरेशंस नहीं थे, सही में कंपनी के अंदर कोई बिजनेस नहीं था, defensively I would like to go with 252 subsection 3. In Bombay I have seen, in Mumbai NCLT bench they don't accept 252 subsection 3 application. I don't know and I don't see any logic behind it, but yes, 252 subsection 3 is nothing but an application, whereas some hope of generating businesses there. I'm not appealing, I'm not feeling aggrieved कि क्यों मेरा कंपनी का नाम ROC ने रिकॉर्ड से हटाया. I'm not feeling aggrieved, I'm not feeling disheartened. जो हुआ ROC ने किया वो सही था, but now we do have some hope of getting some business. And in that case, rather than 252, I would like to go with 252 subsection 3, whereas the limitation period is 20 years from the date the company's name after struck off get published in the official gazette. But सही में मेरी कंपनी में बिजनेस था, आज मेरी क्लाइंट कंपनीज के अंदर बिजनेस है, ऑपरेशंस है, बैंक स्टेटमेंट से दिख रहा है, इनकम टैक्स रिटर्न से दिख रहा है, बैलेंस शीट से दिख रहा है, rather than 250-3, I would like to go with 250-1 and I will prefer an appeal. But अपील करने के लिए जो मेरे को टाइम फ्रेम है वो 3 साल है। मेरी कंपनी का नाम आरओसी ने अपने रिकॉर्ड से स्ट्रक ऑफ किया उसके 3 सालों में। तो जब हम लोग एप्लीकेशन या अपील करते हैं, हम लोग फैक्ट ऑफ द केस में ये स्पेसिफाई करते हैं कि जब आरओसी ने उस कंपनी का नाम स्ट्रक ऑफ किया, व्हाट वाज द पोजीशन एट दैट टाइम, वेदर द कंपनी वाज ऑपरेटिव और नॉट। हम लोग फाइनेंशियल स्टेटमेंट पिछले 2 सालों का देते हैं, बिकॉज आरओसी ने किस ग्राउंड से हमारी कंपनी का नाम हटाया, दैट कंपनी इज नॉट कैरिंग एनी बिजनेस और ऑपरेशन सिंस लास्ट 2 इयर्स। मैं पिछले 2 सालों की बैलेंस शीट देता हूं और ये बताता हूं कि सी द फाइनेंशियल्स, see the projections also. We used to attach projections also. We used to attach financials, and financial parameter itself indicates that company was carrying on its business. Just due to non-filing, the name of the company was struck off. Bank statement we used to attach. We used to attach bank statement, and preferably during the demonetization period, whatever transaction taken place in the company, whatever the banking transaction taken place in the company, we used to attach such transaction also, so that we can easily claim that sirf shell companies के नाम पे हमारी कंपनी को बंद किया, but our company is not a shell company and no suspicious transaction was undertaken during that phase. So we used to attach bank statement also. Income tax return की copy in Sun Corporation हम लोग attach करते हैं कि how regular we were as far as the ITR is concerned. किसी भी चीज में अगर आप अच्छे हैं, you have to demonstrate, you have to showcase that कि हमारे ITR since incorporation updated हैं, and ITR से भी पता चल सकता है कि आप का business जो था, whether it was in motion or not. Of course, charter document, that is memorandum article, shareholding details, PAN of the company, GST number, जो भी आपके पास है, you have to attach that, and you have to attach all the notices which you have received from ROC, and then the matter will be placed before the NCLT. At the first hearing, जब आपका matter list होगा, NCLT will ask for this information. NCLT will give a notice. NCLT will give a notice to ROC. In many of the NCLT benches I've seen, NCLT also used to issue notice to the income tax authorities, and they used to wait for their representation, and based on their representation, the next hearing decides whether it is deserved to get restored or not. But I feel restoration is not a feasible option. It was not a feasible option earlier, when the scheme was not in motion, when the scheme was not introduced. Up to that time, for non-operative company, this was very costly affairs. But now, when the scheme is right now in motion, when the scheme is in existence, I would like to say a company's promoter should opt for the restoration, or we being a professional should insist promoter to get the company's name restored. If they are wealthy, they are cash rich people, they can afford this filing fees, they should opt for the restoration in order to make their slate clean. Because with this restoration, you will be in a position to file all the overdue documents, and with one assurance that ROC will not prosecute you, ROC will not initiate any action on the grounds of this belated filing. So that's it as far as this discussion is concerned. I would like to hand over to the organizer now.
Thank you, Vinit Bhai, on behalf of this platform.
Yes, Vijendra bhai, please. So we have just launched a poll regarding the feedback of the webinar. So all are requested to vote for the same. So first is the for information in the given, and second is that how overall will you satisfy or kind of. So all are requested to vote. Will close immediately within next 15-20 seconds. So, wonderful session by Vinit sir. Extremely useful for all the professional in practice that they can help immediately their client, and also who are in the employment and they can restart their few of the companies or group companies or subsidiaries kind of. A very useful session. You have taken in detail session, sir. So we are very help. It will be very helpful to all the participants and their clients as well. And we got wonderful feedback in both our polls. More than 90-95% we got extremely satisfied and moderately satisfied, and even material also it's helpful, extremely useful, and very useful kind of reply we got in the poll. So we can share both the poll as well, poll result.
Thank you, sir. Thank you very much.
In both the result we got a wonderful feedback. Now would like to request CA Vijendra Bhai, Secretary WRC Vasai branch, WRC of ICI, for a warm vote of thanks to our today's speaker CA Vinit Nagar sir. Over to you, Vijendra Bhai.
Thank you, Virag bhai. Very dynamic speaker, Company Secretary Vinit bhai. Really, I'm impressed the way you start your passion toward this knowledge, your profession, and this CFS scheme. You covered very in detail. I think it is a very benefited for every practicing professional, maybe the chartered accountant or maybe the company secretary, and maybe they in the employment and maybe the student. Matlab you covered entirely at macro level, and the way of your presentation na, it's hats off you on behalf of all the viewers. And whenever this participants is approach for CFS in the ROC office as well as in their practicing office, he or she remember your face, the how you deal the today's situation in 1.5 hours. Really, you are attend to every participant. I thanks on behalf of this platform. It's a very lovely hearing from you, and sharing knowledge is very worth for every participant. Once again, thank you, and looking forward again for this topic, because in every maybe in September one more session is required. I request Virag bhai and all participants get connect with Virag bhai this platform. Definitely, Vinit bhai, because you've taken this topic and again you've taken this topic in detail. That is a very more grateful for and value addition for us. Once again, Vinit bhai, thank you, and looking forward year again ahead. Thank you so much.
Thank you, sir. Thank you.
Yes, surely, Vijendra ji, we will take more session from Vinit sir in the days to come, even in September or any time. We have more session also, and there are more compliance also coming in coming days till the September, or I mean now extended date October or November. So we may require more session to gear up the knowledge of all the professionals. So surely we will touch with the Vinit sir, and Vinit sir are always available for us, and very happy to contribute to whatever manner sir can be. Sir is a very active member in the NCLT also, and he is appearing NCLT, and now in a online mode also is appearing before the NCLT even now and then. In this lockdown also, in this unlocked time, online application with NCLT. So with these words, we can, I think, Vinit sir, anything is pending now? There are few comments for you, that very nice presentation and kind of very, thank you so much, Vinit sir, and thank you, Vinit sir, from Prakhar Jain.
Thank you, Virag.
Thank you all, Surendra Kumar. And few people are asking for presentation and your contact details. Dipesh Gada, thanks Vinit ji. Yeah. So we will share the presentation, and also we'll try to share recording as well. So thank you all the participants for active participation. Thank you all. Thank you, Vinit ji, for wonderful session.
Thank you, sir. Thank you.
Vijendra ji. Thank you. Thank you for joining, Vijendra ji.
Thank you, Virag bhai. Thank you so much.